So it'd be very difficult to find a situation where there isn't a constitutional argument to be made. I'd like you to think laterally here about matters where you'd ordinarily not consider there to be a constitutional issue. Perhaps it's an RAF matter, perhaps it's an issue of goods sold and delivered. There really is some form of constitutional principle that can be made. The Constitutional Court, for example, recently ordered that although a person had missed the deadline for lodging an RAF claim, that prescription ought not to be considered because of all the mitigating circumstances. In that case, there was a constitutional argument to be made in an RAF matter. When we look at breach of contract, we can go back to our founding principles on constitutional contractual law and look at Napier versus Barkhuizen, which you'll remember from your LLB. And again, we've got 20 years or 20 plus years of constitutional court jurisprudence. So there is a lot of information coming out of the Constitutional Court that will inform what it is that you've got to do in your litigation. When conceptualizing a case in general, though, good practice, I believe, is you'll have your first consultation where you don't provide legal advice. You then take a hot minute to research all the types of law and all the cases that fit together in support and in aggravation of your case. You put that down in a massive tree diagram, mind map, and from there you can start putting together what it is that your case will be. This is where you'll start choosing sources of constitutional law to add flavor to the case. Nobody's suggesting that on the outset you'll be able to identify everything that your client needs when in the first consultation. I'd like you to do a little experiment for me now. Take the example that I'm giving you and try and think of all the rights you can come up with where all the rights that have been infringed with this example. A woman walks into your office and says that she's been run out of her village because everyone in the village has accused her of being a witch, and so she has been made to leave her home, made to leave the place where she works. She has nothing. What rights do you think have been infringed by the situation, and what remedy would you recommend to her? To my mind, the first and most pressing one would be the right to not be evicted arbitrarily. So we would use an enabling legislation such as PI, because she's been unlawfully evicted. We'd also say that there's a right to choose your own work. There's the right to property in terms of Section 25, right to freedom of religion, freedom of speech, freedom of association, and dignity. I think these are all rights that you can hinge on, and the remedy would depend on what the client wants. But there's a rave indicatio. I would also, and of course, even though it's a common law remedy, you can still bring in constitutional arguments. You'd also ask for a declarator that the conduct of the people in the village was unjust, unlawful, and unconstitutional. There would also be an equality argument because she was being discriminated against. So would you bring your remedy in terms of the rave indicatio if what she really wanted was her house back? Would you bring it in terms of the Equality Act and therefore in the Equality Court? Again, this would heavily depend on clients. What I want to say about the onset of litigation and when you consult with your client for the first time, clients won't know what rights are. Clients won't necessarily understand what they are and are not able to ask for. An example of this is when a gentleman walked in for a consultation and told me that his human rights had been infringed. And I asked him why his human rights had been infringed. And he told me he had sold his car to someone who, before paying the full purchase price, had driven the car to Botswana. And no police station would assist him in getting his car back. For him, he thought this was a rights-based issue. He thought his human rights had been infringed. Indeed, his right to property has been has been infringed. But if we go back to the principle of subsidiarity meaning we go for common law or enabling legislation before we go for a direct constitutional argument. This gentleman, perhaps his rights haven't been infringed so much as he's been robbed, which arguably is an infringement of rights, but you wouldn't go by way of rights-based litigation to get his car back. All I'm trying to illustrate is that clients won't know what information to give you, and you need to be more conscious of the information you need to ask for. And clients won't know what a right is, won't know what the Constitution necessarily says. Another issue I want to caution you about is that clients lie. Clients will tell you fibs in order to try and get you to be on their side. You will give clients, obviously, the information that the conversation you're having with them is privileged, that you need them to be as open and transparent as possible, and still they'll lie. They'll lie for a whole bunch of reasons. Sometimes clients are really scared of consulting with an attorney for the first time, and because the institution of law is really intimidating, they'll tell falsehoods because they think they have to impress you. Clients will lie because they know their case is weak, or because they think their case is weak, and other times clients will lie because they want relief that they know that is not owed to them. As an attorney, you'll know that sometimes these stories just don't make sense. An example I had is a client came in asking for an assistance with a refugee matter. She had told me she was from a country that very commonly has refugees coming into South Africa because of the political unrest, a country where journalists are often murdered, a country where rape is used as a weapon of war. She told me that her husband was a journalist and had been killed. She didn't have any articles that he could have possibly written, and I couldn't find them online. She also told me a terrible story about how she had been raped in front of her mother. I went through a different line of questioning and then returned to the rape incident. And the rape incident changed very dramatically, and it got worse every time I asked her. Her emotional affect didn't change. Eventually I told her, look, I was there to help her no matter what it is, and that perhaps she wants to take 10 minutes to consider that, but that I need to present the truth. And I'm not going to be able to help her if what turned into a harrowing story about sexual violence then turned into a harrowing story about sexual violence that ended with being dragged through the town steps and speaking to the mayor. There was something that was, although very disturbing, very untrue about her delivery. You can trust your gut on this. I've had situations where a client came in, her husband had recently died, and she needed an application to register her customary marriage in the High Court, which was absolutely not a problem. I was very happy to do it. She wasn't able to get access to his pension benefit because their marriage was never registered. In the 6-month journey that her and I walked, I was a candidate attorney at the time, and I was consulting with her. I never thought to ask if her late husband had children with another woman. And she never told me. And at the point where we were almost finally able to wind up the estate, there was a complaint from another woman that her son, who was the oldest son of the late husband, was also entitled to his share of the inheritance. And indeed he was. It became very difficult to scramble that egg. I hadn't asked that question because I believed that my very sweet and kind client would have volunteered that information to me. Be circumspect about clients. They might not know that they're withholding information. They might know that they're withholding information, but you need to be thorough because you are still a stranger to your clients, even though you know you're there to help them. So your client comes in and you have consulted, they've told you what they want. You've gone back, you've done all the research, you've consulted again to tell them what their options are. Please do not consult until you've done the necessary research. or unless you're absolutely sure. But if there's something even slightly new or novel about what this client has told you, consult once, give them a discount if you want to, so that they don't feel cheated. Go back and research the case. And remember, as attorneys, we are not permitted to charge for research. And then consult with them again and give them their options. This is the way to ensure that you are practicing law in the best possible way. If you're going to give advice straight off the cuff when you're not 1,000% sure of your answer, you may be leading your client down the garden path, charging them for unnecessary hours and ultimately not being able to help them. From a business perspective, this is not going to help you in the long run because you will not get recommendations from that client and you will not get repeat business from that client. Rather do it my way. So once you've done this, you've consulted, you've researched, you've consulted again, and your client has chosen the route they want to take out of the options that you've given them, then you're drafting your letter of demand. Your letter of demand is going to be a little mini notice of motion and a little mini founding affidavit. It's going to abbreviate what it is you're asking for, and it's going to abbreviate the facts that line up for that line up to you asking for this demand. Your letter of demand is going to be the number one key tool in your arsenal in terms of litigating on constitutional issues. If you can show that you've been consistent from the start about what it is that you wanted and what it is that the client needed and how their rights were infringed, and you take that all the way and you bring in constitutional arguments in your letter of demand, you're clearing the path ahead of you. If your client is satisfied with relief that's being brought from the letter of demand phase, pat yourself on the back. Their client's happy and infringement, perhaps if you're bringing a rights-based argument, has been finally settled and you can go on your merry way. That client is going to recommend you to 50 of their closest friends. Because remember, at the demand phase, you've already cautioned your client that if we have to litigate possibly through the entire route to the Constitutional Court. You know, you'll go Pretoria, Bloemfontein, Braamfontein. This is a very expensive journey to go on with your client. And if you can caution them on that is a sad possibility, and you get everything right at the letter of demand phase, you're absolutely golden. If, however, you don't get what you want, especially if you're litigating against the state, they'll ignore letters of demand, then you're going further, but you can show cogency and consistency in your argument to your client, to the judge, and to the opposing party at all stages. You look like the real good guy. If you keep obfuscating your argument and changing it from letter of demand to notice of motion to an amended notice of motion to the appeal stage, it's not clear anymore what the infringement is. And again, this goes back to that earlier research that I said you should do after your first consultation. Keep on adding to that mind map as new case law develops, as more information becomes apparent. But if you've been mindful of both case law and litigation and common law that supports your case, as well as customary law, obviously, that supports your case and one that aggravates your case, at that stage, you're going to have a clear view of where you should go. It is the right thing to do, and it saves you time and energy and drama later on down the line. So what you do going forward after that is you think about the structure of, let's focus on rights-based litigation. You think about your structure. The procedural structure is, I also want to just highlight that these are generally applications as opposed to actions. They're generally applications because the conduct will be common cause. What will not be common cause is whether or not that conduct or that legislation amounts to a rights-based infringement. So we start off knowing that we're dealing with an application. Our first question is, does the Bill of Rights apply between the parties? This is your horizontal versus vertical application of the rights. Your horizontal application is going to be between two parties, two private persons. So this could be between your employer and you. This could be between a newspaper and you. or your client rather, this could be between any two sort of private persons. Then we go for the vertical application, and this is between the state and you. The other question is the respondent, your would-be respondent, bound by the Bill of Rights? Now, that we know that there are certain parts of the Bill of Rights that has vertical and certain parts that has horizontal as well as vertical application. Your right to, let's say, your right to vote, that is something that's enabled by the state, but arguably, if a private person was locking you up for the purpose of preventing you from voting, they would be bound by the right to vote. Right to dignity, you see a lot of horizontal application. Somebody said something very upsetting about me, and I feel that my dignity has been infringed. That applies between private persons. The other question is this a direct application or is this an indirect application? I mentioned a little while ago the principle of subsidiarity. So subsidiarity again says if there is, first, enabling legislation from the Bill of Rights, such as the PI Act, the Esther Act, the Promotion of Administrative Justice Act, the Promotion of Freedom of Information Act, the POPIA, the Privacy Act. These are all bits and bobs of legislation that give effect to rights. They're enabling the rights within the Bill of Rights. So if we go by way of enabling legislation rather than directly to the Bill of Rights, that is taking into account the principle of subsidiarity. You must always take into account the principle of subsidiarity. So if you can go by way of common law as opposed to direct application of the Bill of Rights, you must. We don't throw the baby out with the bathwater. We need to have the enabling legislation being taken along in the journey with us. You will be kicked out if you go, for example, your matter will be struck if you are bringing an equality argument, such as unfair discrimination, and you don't bring it in terms of Papuda and in the Equality Court, and you want to go just by way of the Constitution in terms of your right to non-discrimination, the court is going to strike you because your jurisdiction is wrong. If you say that you have the right to access to information and you don't use PIA, Promotion of Access to Information Act, and you go directly in terms of your constitutional right to access to information, the court is going to bat you because you're wasting their time by not going through the right legislation. This again harkens back to all the research that you have to do to ensure that you are on the right path. Somebody has an issue with access to information, then in your research, creating your spider diagram, your mind map, you will look at PIA and see how it applies. So make sure that you're using the principle of subsidiarity. Then, after we know whether or not we're going for indirect or direct, if you want to look at the constitutional principle there, look at Section 8. The next thing we're going to do is look at justiciability. Now, if you remember what I had said previously, justiciability is your ability to have this matter adjudicated in a court. Do you have standing? Is it ripe or is it moot? And are we going against the correct respondent? Then, are we asking for the correct relief? So if you want to take a look at the relief that we would be seeking, you'd take a look at Section 38 of the Constitution. The next step we're going to take a look at is jurisdiction. Are we going in terms of the correct court? Now, we know that there is one high court in South Africa with many divisions for the various provinces, but then there are also specialized courts. We have the Specialized Commercial Crimes Court, we have the Tax Court, the Electoral Court, the Land Claims Court, the Labour Court, the Labour Appeal Court, there is the Competition Court, And a couple of others that I'm missing out, and then there are tribunals that have the same impact as the various high courts. Are you going in terms of the right course? So, for example, you will look at the enabling legislation to find out. ESTA, for example, the Extension of Security of Tenure Act, says that the only two courts that have jurisdiction are the Magistrates Court or the Land Claims Court. So you can't bring that in the ordinary High Court. The ordinary High Court has no jurisdiction. Election matters, the Electoral Court has jurisdiction. Labour Court is an interesting one because the Labour Court has jurisdiction, but you can bring labour matters in the ordinary High Court. What would be better? Probably taking it directly to the Labour Court. So, jurisdiction is not something that you take as a given. Oh, the Magistrates Court and the Small Claims Court can't develop the common law and can't decide on constitutional issues, so I'm just going to the High Court. No, you have to think about the specialised courts as well. Then we go into our substantive section. This is our interpretation of the rights that would be infringed in the Bill of Rights. So when we want to determine whether or not, when we want the court rather to determine whether or not law or conduct, the conduct of the respondent, of course, was an infringement of rights, and whether that's applicable, we look at section 39.